begin recording. I wanted to, for the Women's Council North Metro Denver, always thank and appreciate our diamond level strategic partners who are Exit Realty and Elevations Credit Union. We're always appreciative of them, and we would not be where we are or be able to function without all of our strategic partners, but we certainly wanted to highlight our two diamond strategic partners this morning. Dee, I am now going to take the opportunity to ask you, who would you like to acknowledge for your strategic partners with the Pikes Peak Network?
Well, thank you so much. I didn't get anybody, but they are so great. We do have a land title representative, Lakin Erickson, and she's been awesome. They close on time and they're great, and they're a gold partner. So I appreciate giving a shout out to them.
Thank you,
Thank
Dee.
you.
Is Tammy, I'm sorry, I'm going to butcher her last name, from Fort Collins, is she on this call? Well, I know our very own Beth Ann with Mile High is, so would you like to speak on and acknowledge a strategic partner that you appreciate?
Yeah, you know what, Angela Grunst, oh my gosh, Roof Brokers, she shows up to gosh darn everything. She is just there for us whenever we need. So I definitely see her out there. Also, I wanted to just call out First Integrity Title. Lauren Collins, our rep, just joined up literally like 5 minutes ago. So she's our newest sponsor. So yay! I don't think she's out here though, but that's okay.
Thank you, Beth Ann. So
thank you.
Everybody that is, excuse me, arriving late, I just want to ask you if you are interested in the CE, 2 CEs for this course, to please put your first name, your last name, and your email in the chat. We will be asking for attendance halfway through and again at the end, but to receive that CE, if you could do that for us, that would be appreciated. So I am going to begin a screen share. Please be patient with my technology abilities. I may be a little slow.
You're killing it, Dar.
Thank you. I am going to share this screen with everybody. Everybody see that? Perfect, thank you. So this course is called Death in Real Estate, and Vince Buzek is someone from the Broomfield area that handles, specializes in estate planning and mediation services. He deals with trusts and wills and medical power of attorney, financial power of attorney, living wills, and advanced directives. He will, of course, go into depth with regard to what he offers with his law office. Just a little bit about Vince Buzek. Vince's practice focuses on estate planning and real estate issues, two of the most important legal matters most people face. Having practiced for more than 30 years, Vince is well versed in the law and has experienced a multitude of situations which provide his clients with the best advice for their individual needs. Vince has been involved in his community since moving to Colorado 25 years ago, having served on Broomfield City Council and currently serving as an RTD director on their board. Overview of this course, Death in Real Estate. This course is designed to impart basic to intermediate knowledge of the impact of death on the real estate transaction. Topics will include methods of transferring real estate in Colorado and buying or selling property owned by a trust or which is in probate. We will explore the impact of death, probate, trust administration, and title on the real estate transaction. Other topics, which include post-transaction protection of the real estate asset, the various real estate planning techniques and the legal principles behind each technique. So with having said all of that, we appreciate you presenting this morning, Mr. Buzek, Mr. Vince, and I will hand it over to you.
Great, thank you. And I want to thank the Women's Council. I want to thank Darlene Mader for putting this all together, and all of you who are virtually assembled for being here. So, and as Darlene said initially, at any point in time, please feel free to stop and ask questions. I think we get a lot more out of any kind of continuing ed class when there's an interaction like that and not just a dry recitation of principles and facts. And I don't like doing that. So I got a little bit more about me. Oh, you saw I'm an RTD director. So if you guys have questions about RTD, I'll take those offline. Anyway, I got an interesting email the other day for a continuing legal education class. And it was about trust and estates and things like that. And one of the facts that it presented was that by the year 2061, it is estimated that $59 trillion worth of assets will be passed down from the baby boomer generation to their beneficiaries. So that's kind of a lot of dough. And you know, as we all age, I know there was some talk before this presentation about someone that just got their will and stuff done, and you know, I've had people come to me for the first time, you know, in their 60s and 70s that have never done any kind of estate planning, and think that maybe now is a good time. So when's a good time to start that? Right now. Well, that's the answer. So so you can see there's a lot of stuff that's going to happen, and what we want to kind of focus on here in this class is what happens when someone dies, you know, either for the real estate transaction, during a real estate transaction, and sometimes the death before kind of pushes us into the real estate transaction. I'll try to lighten it up a little with a few stories along the way. And you know, after you practice law for a while, you kind of figure out why there are all these provisions in contracts and things, right? Because just about every paragraph of a contract probably has a story behind it. And after practicing for a while, yeah, you find you kind of think, wow, I never thought that would happen. And here we are in court. So there are a lot of things that we'll talk about in that regard, and impacts on you guys as well as realtors, and how that can affect you. And one of the things I'll talk to you about is I just got done with a jury trial in Fort Collins, the first jury trial in a year. So you know, jury trials in civil cases have not been happening. So this was the first time in a year that we've had a jury trial, and it had to do with an interesting concept we'll talk more about later. You guys probably have heard about it. It's something called seller's property disclosures. So I'll give you that little teaser right there. We'll talk a little bit more about that as we move forward. So just some fundamental background.
Interrupt
Yep.
a quick second. I know there's still a lot of people jumping in last second.
Oh, sure.
And because we're now at a point of time cutoff, if you're interested in the CE, please put your first, last name, and email in the chat box. That was all I had. Take it away. Sorry. No,
that's fine. So the first thing we'll talk about is what are the different methods by which people can hold title to real estate. So one of the obvious common ones is that you have a sole owner of a piece of property. They're the only name on the deed, and no one else is there with them in any other fashion. And in the days long ago, you'd refer to an individual male owner as a bachelor and an individual female owner as a spinster. And thank God we don't say that stuff anymore. So that's one way that you can hold title. The probably the most common way, especially when more than one people are holding title, is through a joint tenancy. And we all know about JTWROS, right? Joint tenancy with right of survivorship. Important concept, because you know, when one joint tenant dies, we're talking about death, title immediately transfers to the surviving joint tenant. There's no need for any intervention of a court or anything else. It's an easy breezy, not so easy if the spouse is dead, but yeah, it's a simple way that property gets transferred.
Sorry, one last interruption.
Yeah.
Anyone that needs that CE has to have their camera on. I have not expressed that apparently clear enough, that you have to have your camera on as well during this presentation, because that's not happening. But anyway, sorry, Vince, go
Yeah,
ahead.
no problem. So another thing, another way to hold title is as tenants in common. And you guys all, I'm sure, know this, but a tenant in common, each tenant holds an undivided interest in that property in whatever proportion the deed says. And if it doesn't say, it's usually 50-50. So what that means is when one of those tenants in common dies, their interest doesn't pass to the surviving tenant in common. It passes pursuant to whatever estate plan they have in place. And if no estate plan, then by another complicated process of statutes that kick in. So why would people want to have property held as tenants in common? Well, I see this often in investment properties or vacation properties that are held by unrelated individuals and owned by unrelated individuals. So you've got a mountain property in Breckenridge, and 3 families have gone in to purchase this thing. They may want to have title held as tenants in common, defining their interests, and so that when something happens to them, they can dispose of their share of that property how they see fit. So first story of the day has to do with a matter I handled a few months back, where it was a husband and wife, and the husband had died, and the wife was going to refinance the property. When they went through that process, they discovered that 20 years ago, when they bought the property, for reasons unknown to anyone, the property was titled to them as tenants in common. Specifically says that. So I think the fallback, the rule in Colorado, if it doesn't say anything, it's tenants in common, right? So it said specifically they held as tenants in common. Probably a mistake somewhere 20 years ago, but now the surviving spouse, the wife, had to go through the process of probating his estate. We'll talk more about probate in a little bit, so that she could get the title to the property transferred into her name alone, and then go through with a refinance. So it's interesting that these things happen, and again, this is all these little things that occur that are unusual are what lead us to taking hard looks at these things as we're moving forward. Another way that you can have an interest in a property is through a life estate. Doesn't happen very much anymore. It used to be a fairly interesting concept, and what would typically happen is sometimes a life estate will be defined in the deed itself. Sometimes it'll be defined, for example, in a will, and the will will say, husband may own a separate property, or wife, whoever, spouse one, owns a separate property, and says that when I die, I give to my surviving spouse a life estate in that property. It allows them to remain in that property until their death, and then the property transfers to whoever they designate after that. Not a common method of holding title anymore, but story number 2. I had one of these a few years back right here in Broomfield, where this was with the parents, and they had a number of kids that were not all on good terms, and dad died, and he owned the house in Broomfield in Gaydon Green. I don't know if you're familiar with Gaydon Green. It's a senior only kind of a community in Broomfield. So dad died, had the property just in his name, and his will granted the life estate to surviving spouse. You get to live in the property until you die, and you need to pay the taxes and insurance while you're living there. There was no mortgage on the property, which was good because the will didn't say anything about that. So the will, unfortunately, was silent on a lot of things. So I have one of the kids that comes forward and says, she's elderly, she's not taking care of the property. We've driven by a number of times. She's not maintaining the property. We're concerned that it's going to diminish in value over time because of this. So we reach out to her and her attorneys to try to figure out what can we do. But because the will was silent regarding her responsibilities as to the property to maintain it or keep it up, so other than paying the taxes and insurance, she had no other obligation to maintain that property. And so you got a situation where the potential owners of this property, the remaining kids, were watching an asset just waste away, and so that's problem. Not a probably a good way generally to hold a title to a property, and you don't see it very often anymore. So there's your first two stories of the day. I'll try to keep them coming. Before we move on, any questions on this kind of stuff or any of the stuff we've discussed? If not, I'll just keep on going. So how do people transfer title, generally speaking, right? The typical way is through an arm's length transaction. It's what you guys do well, I was going to say every day, but God, not so much anymore. What's with this market? So typically arm's length transaction, right? You've got a willing buyer, willing seller, and you get a contract, everybody is happy, and you buy a house. And typically you transfer title to property in that regard, either through a warranty deed or a special warranty deed. And these are deeds that kind of come with some guarantees, right? So typically the seller warrants or guarantees to the buyer, I've got good title, blah, 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 things like that. So that's your best kind of a deed, right? Your warranty deed, because it comes with guarantees. Another way to transfer title is through something called a quitclaim deed. And this happens a lot in a lot of different circumstances. We'll talk a little bit more about trusts and things like that, and some of the concepts behind them. And typically when you create a trust, there's always going to be a quitclaim deed transaction associated with it. So quitclaim deed basically says, you get whatever I get. I'm not making any guarantees. If there are encumbrances or if there are lot line dispute, whatever I have, you get, good, bad, ugly. So sometimes that's okay if you know what you're getting. Always a good idea to have the title company, right? Take a look. That'll be a requirement. So that's a interesting way to transfer property. Doesn't give you any guarantees. Then we have certain transfers on death. So there are a number of ways you can transfer property, or property can transfer upon the death of the owner. One is through something called a beneficiary deed, and we'll talk a little bit more in detail about this. It looks a little like a joint tenancy, but it's not. So it grants to a beneficiary, usually an heir, a kid, somebody in the line of succession, the right to get the property, but only upon the death of the owner. Okay, sounds cool, but we'll talk more about it later. There's a lot of restrictions that come along with a beneficiary deed. Other ways to transfer are through something called a personal representative deed. And this is what always comes out of a probate action. We're going to talk about probate in just a minute. So a personal rep deed is a deed signed by the court-appointed personal representative of an estate, and transfers the property to whoever they want to transfer it to. Typically comes, as a result of a death in the family, surviving spouse dies or both spouses are gone, and whoever comes in and says, we're going to sell this property, personal rep's going to sign that deed. You need somebody signing a deed at the closing, and the owners are not around anymore. The other way is through a trustee's deed. And this is another deed that comes out of an estate situation, but it comes out of when people have their property held by a trust. And we'll talk more about that later. So instead of a personal rep signing the deed, it's a trustee under the trust that signs off on the deed. So they're pretty simple, pretty straightforward. Not a lot of complications other than that beneficiary deed. Like I said, we'll talk a little bit more about that. What kinds of transfers can affect our title insurance coverage? Well, that's always an issue, right? So you get title insurance, and the title insurance covers you for any number of defects that may exist in the chain of title of the property. And to a buyer, it's pretty important that they have this. Sometimes though, buyers can do things to impact that title insurance, because the title insurance is given to them, typically the individual owners of the property when they buy the property. I alluded to the fact earlier that if you have a trust, you'll transfer the title to your property into the trust by a quitclaim deed. So the trust now owns your property. So technically, title is no longer held in your name, but as a general rule, your title insurance policy will still be effective, provided that the trustees of your trust are the same people that bought the property, the same people that are insured under the title insurance policy. There can be an exception, and there's a special kind of a trust out there that's called an irrevocable trust, which means that once you do the trust, once you transfer the property out of your individual names and into the name of this trust, you can never change this again, ever. So, because of that, and for a number of other reasons, I'm not a fan, but some title insurance companies that I've spoken with say that could be an issue with title insurance coverage, because one of the other requirements of this irrevocable trust is that the people transferring the property out of their individual names into the name of the trust can no longer really be associated with the control of that trust anymore. And so someone else is in charge of that trust. And some title insurance companies say, that's kind of almost like a sale, because we've got not only just the trust holding it, but another person or entity in charge of that trust. So those are things to watch for when you're looking at trust issues and the title insurance policy and how that policy continues after the transfer. So let's talk a little bit about probate, because I've alluded to probate a number of times, and I'm sure most of you know, or at least have a kind of an idea about probate. So probate is a legal process of administering a person's estate after they die. So someone dies, what do you do with their stuff? That's what an estate is. It's your stuff, whether it's real estate or personal property or bank accounts, retirement accounts, all kinds of things can be part of your estate. So it's kind of important to understand the basics of how probate works, because obviously we're talking about death and its impact on the real estate issues and transactions, and probate can be a problem in a lot of ways. So, like I said, it's a court supervised process. Okay, so there are some triggers that make you go to court to administer someone's estate. Don't always have to go to court. If you don't own real estate, if the person doesn't own real estate, or they don't own assets in excess of $68,000, you can probate. You can take care of their estate without probate. So, mom and dad die, they live in an apartment, they just have stuff, furniture, furnishings, mementos, memorabilia, things like that. Kids can come in, do what they want, divvy it up, take care of it, and move on. And there's no requirement that the court get involved, and you go through this process where the court kind of supervises what's going on. But like I say, there are certain triggers that make that a requirement. And the biggest trigger is ownership of real estate. And that kind of gets us back to the personal representative deed, because let's say mom and dad own real estate and they've got 2 kids. Whether they have a will or don't have a will, they die. And the kids say, okay, we want to sell this property and split up the proceeds or do what we're going to do. Well, someone has to sign a deed at the closing, right? Because there's always going to be that end of the transaction where everybody sits down in the title company, and the title company people are shuffling papers and telling you what they are. And you get to the one most important document, and that's the deed, right? Who signs that? Well, the personal representative signs it. Well, who's the personal representative? It's the person the court says is the personal representative. So there you go. Here's the court process. Whether you have a will or don't have a will, and you own real estate, and there's no joint tenant left to take it. Now you're going to court. And sometimes that process is smooth and easy. Sometimes. And here's some more stories. So a few years back, had another jury trial, this one down in Arapahoe County, over an estate. It was a will contest, right? And it involved the real estate that was held by mom. So mom, elderly mom, no husband, sole owner of the property. Black sheep son moves in with mom, right? Adult son, in his 50s. Moves in, comes out of nowhere and moves in with mom and shuts out brother number 2. No access. You can't see mom. She don't want to see you. Okay. Later, a couple years later, mom dies. And brother number 2, the shut out brother, says, okay, brother number 1, what are we going to do with the house? And brother number 1 says, well, there's nothing to do. Mom left it to me in the will. So we have an issue of a will contest. And brother number 2, my client, says that is not what mom has talked about her entire life. So we have a jury trial, Arapahoe County, undue influence, and make all these allegations that the one son who came in, isolated mom, drove her to the attorney's office, sat there while she signed a new will, may have had something to do with that. So I allude to that simply because probate's not always clean and easy. And when you have a will or don't have a will and you end up in the court system, things can go south pretty quickly. The statutes that regulate wills and estates and probate define a lot of different people in a lot of different ways. One of the most important definitions is what they call an interested person, because an interested person has certain legal rights in a probate matter to come in and question things and make a mess of things sometimes. Interested persons in the Probate Act there are a lot of people that will fall within the definition. Even remote relatives can potentially become interested persons. So I raise this issue because there are we're going to talk a little bit more about methods of avoiding these issues down the road. But when you have this process of probate, even in its simplest form, it's going to take you a minimum of 4 months to get in and out. I mean, that's in the most perfect world that in 33 years of practice, I've never seen happen. You're going to be looking at least 6 months from start to finish, and maybe longer. I've got one where I represent a claimant, someone who's making a claim against the estate. The estate owes me money. That it's been open for 2 years, and still things are going back and forth. So I'm trying to give you the sense that, yeah.
Going back to beneficiary deed, does a beneficiary deed need to be recorded before death?
Yeah, absolutely, before death. because death is going to be the trigger to give you the benefit. So if it's recorded after, I think you're going to have a real big problem. So yeah, it does. And we'll talk a little bit more about those too. So you can, we'll get to that. Anyway, keeping back to the probate stuff. So that's kind of the story, the crazy story on the probate side. So trying to give you the sense that probate can be problematic. But what comes out of the probate is the official appointment by the court of your personal representative, and that's the person that can actually sign the deed and all the other paperwork at the closing. They've got full authority to act on behalf of the estate. They need to pay creditors of the estate. They need to publish notice in a newspaper about the death so that unknown creditors can come forward and all kinds of things. So anyway, that's kind of
Mr.
a nutshell.
Buzek,
Yeah.
I'm sorry, Alex Strauss here. I have a question in regards
Yeah.
to the probate. So let's say we have a situation where the wife dies and then the husband is then sole proprietorship of everything. What if one of the children actually became attorney in fact, so gets a power of attorney? Would that have any influence on the probate in case the second parent also passes away? Would that change everything if there is a power of attorney for one of the children?
Okay, and so whose power of attorney is it? Is it the living dad or the dead mom?
Exactly, of the dad in this case.
Okay, depending on the nature of the power of attorney, son, as the agent under the power of attorney, can act on behalf of dad as defined in the power of attorney. Now, if mom has died and they own the property as joint tenants, dad immediately becomes the sole owner of that property. So moving forward, if dad's the owner of the property and son has a power of attorney, a lot of things could be in play here. It depends what the power of attorney says about when it becomes effective. Is it effective immediately upon dad's signature on it? Does it become only effective when dad becomes declared incompetent or whatever? And then the level of authority of the son is going to be defined within that power of attorney.
Yes, and what if there are other siblings also in place? So let's say the dad also passes away, then we have, in this case, it was 3 siblings. One of them had power of attorney. Would that impact the probate or the representative that you were just talking about?
Yeah, sure.
In terms of who will manage the estate that's left.
Understood. So depends. If that's the perfect attorney answer. It depends. So if dad left a will, typically the will should say who dad nominates to be the personal representative. The court will give a great amount of credence to that designation. If the dad didn't leave a will and you've got 3 siblings, the sibling with the power of attorney may argue that because dad gave me this power of attorney, he clearly trusted me with regard to financial matters, I should be the personal representative of the estate. If the other 2 children don't agree, now you've got a contested appointment of a personal representative. It moves you out of something called informal probate into formal probate. Even more court supervision and involvement. So if dad leaves a will and the will says, child number 1 is my personal rep, more than likely the court's going to appoint that child as the personal rep, but the other kids could still come in and say, oh, no, that child's a basket case. You can't give them this authority. So you could still get into an argument over the appointment of a personal representative. Once the personal representative is appointed, if dad's will is silent on what to do with my stuff, like the house, the personal representative has full authority over what to do, as long as it's done equitably with the other kids. Does that help?
Okay. Yes. Thank you.
A couple more questions came in, Vince.
Yes.
So I'm assuming a probate only applies in the event of a quote unquote will only. If a living trust is in place, probate would not be non-applicable, ? Is this true?
Sure. So to clarify the first comment, probate can happen without a will as well. So yeah, but I get where you're going. So probate is going to happen when you have real estate held in the name of the deceased, whether they leave a will or don't leave a will. With a living trust, you avoid the entire probate process completely. No probate, you don't open up claims to these interested persons that you would in a will situation, a probate situation. The transfer doesn't take 6 months to 2 years, it's immediate. So a lot of benefits to the living trust.
Next question. What type of power of attorney does it need to be? A past client, oh, my screen just jumped. A past client had a durable power of attorney and the title company didn't want to accept it because it didn't state the address, only any property.
Okay, so I know there may be some title insurance people in this session. So insurance companies, title insurance companies, hospitals, healthcare providers, they get to kind of make their own rules to protect themselves. And sometimes those rules don't have a rational relationship to the law, but they can make those rules. So if a title company says, I'm not going to honor this durable power of attorney because it doesn't specifically name the address to which the agent has power, but only says any real estate that I may own. Well, from an attorney standpoint, that power of attorney is just fine. From a title company standpoint, they want to really protect themselves. They want to make sure that they're not going to be other people coming out of the woodwork saying, "Wait a minute, that power of attorney didn't say that exactly." So yeah, so there are situations where, yeah, healthcare powers of attorney, same kind of thing. So here's the new rub on those things. I don't want to get too off track, but people might find it interesting. Healthcare power of attorney, same kind of thing. You name someone to make medical decisions for you when you can't, right? You're in the hospital, you can't communicate your wishes. Hospital needs to do something, and you appoint an agent to make those decisions for you. Some healthcare providers are now saying they will not honor a healthcare power of attorney that is 5 years old or older. Mind you, the healthcare power of attorney does not have an expiration date, doesn't have a use by date on here. It is good under the law until the person who made it revokes it. But hospitals are making these rules because they want to make sure, they're trying to cover themselves from liability. I get that, but sometimes it's a problem, especially when, child is in and parent is in a coma and they present the 6-year-old power of attorney and the hospital says, sorry, you need to go to court and be appointed a guardian and conservator. Doesn't happen often, but believe me, it's happened.
The follow-up comment to that was they ended up taking it because the dementia had progressed too much for him to do a new one. So that's
Exactly.
the resolution on that one. Next
Yeah.
question, are living trust and family trust the same?
Yes and no. A family trust is typically a living trust. What's different is just the way it holds the asset and the way it distributes an asset. In my experience, what people call family trusts are, parents own a piece of, in fact, another story I have, parents own a piece of mountain property, 40 acres, in Summit County, really nice. They want to hang on to it, right? They want to keep it in the family. So they create a living trust, which basically puts the title out of their names into the name of the trust. And then the trust document says, here's how it gets used. Here's how it gets used when we're alive. Here's how it gets used after we die for a period of time. Can't control that stuff forever. And then talks about, the family, they create a family compound, whatever. So that's kind of my experience of family trusts. They are typically a living trust that has express ways of using the property and keeping the property in the family for as long as you can.
And then the question came up, I know you're going to address it here in just a little bit, but what's the difference between a trust and a will?
No difference. They're all the same. No, I'm kidding. Big difference. And so here's what they both do a lot of things the same way. A will and a trust both dispose of your property in the event of your death. They're both perfect to do that, right? They both take into consideration your intent and your desires upon your death. With the will, as we've heard in some of these discussions, if you have real estate, there is a good chance you're going to probate unless you're the surviving spouse that takes under a joint tenant deed. And if not, you're going to probate, you're incurring expense and time that it takes to do that process. If you're in the trust side of things, you avoid probate completely, and the transfer, or the ability to transfer the property from the name of the trust to whoever is intended is immediate. So you've got a big money saving, factor and a big time saving factor with wills and trusts. They do both do the exact same thing. Dispose of your stuff when you die.
Except one avoids probate.
Yeah, right, exactly. And that can be pretty important.
If, 4 months minimum is what you said. So that was
Yeah.
all the questions that we had.
Yeah, good. No, keep them coming. I appreciate it. And can everybody hear me okay? Am I okay?
Yep, sounding great. Another
good.
question just came in. Do you recommend trusts then?
Yes, short answer, yes. I have a trust. Yeah, I do for a number of reasons, and we'll talk a little bit more about that as we go on. But the two big reasons we're right there. All right, so transfers on death. How do you transfer property? So if you're the sole owner and you die, we've alluded to some of this, but it's going to pass pursuant to a will, and if there's no will, it's going to go to someone. This is all going to involve probate. So if there's a will, your will is going to say what. Sometimes it'll say what you want done with it, but it will at least appoint a personal representative who can make those decisions, right? If there's no will, we call that an intestate estate. If you have a will, it's a testate estate. You don't need that unless you're taking the bar exam anytime soon. So, but so when you have an intestate estate, no will, generally speaking, the property will probably go to who you want to get it, right? But not always. So we have this thing, law school question. It's called a table of consanguinity, and it has been reduced to statute in Colorado and every other state that says if you die with no will, here's who inherits your stuff. If you have kids, here's who gets it. If you have kids, grandkids, and one predeceased kid, here's how that goes. You have no kids, but you have parents, brothers and sisters, aunts and uncles. So it addresses all these different scenarios. And like I say, most of the time, it'll probably get transferred the way you would have wanted it to. Let's say you die, you have 2 kids, that's it. The kids are probably going to get that property. But what if you die and you've remarried and you've got a blended family with kids from other relationships? Who are your kids and who are not your kids? Does your surviving spouse take everything, or do your kids get shut out? So those are things that where things will happen that you don't think you would have wanted. So whether you have a will or a trust, you have something that says what happens to your stuff when you die. But so when you transfer as a sole owner upon death with no will, Yeah, it can be a problem. And as one of our questions was, it can be a problem just getting a personal rep appointed. I've got one now, and thank God we're still doing things by WebEx is what the courts use. But I've got a case in Sterling, Colorado. I'm not even sure where that is, but I think it's like next to Nebraska. So I've got this case where we've got an intestate estate. Dad, mom was the last to die. No will, and there are 7 kids, 7. And guess what? They all want to be the personal representative, and they all have a different idea about what to do with the property. So, as you can see, not having a will is bad. Probate is bad. So we'll be in contested hearings and all kinds of things in the next couple of months on that. So
So
how
question
about,
with regard
yeah,
to family. So I was told trusts are better than for families with small children. Is that correct? And is there tax benefit to have a trust?
okay. So trusts are better for anyone that owns real estate. I think that's the biggest trigger you need to keep in mind. Kids, no kids, it doesn't matter. A trust will do exactly what a will do. It'll provide for young kids and so forth, just like you can do that in a will as well. But you're going to avoid probate on the trust side, not on the will side. But yeah, you can if you've got kids. So those are important things to think about. You need an estate planning document. You need a dispositive document, something that disposes of your stuff when you die, right? Will or trust. I like trust. They can say the same things. Typically an estate plan like that says spouse 1 dies, give it all to spouse 2. If spouse 2 is not there, or if you die in a common disaster and you leave minor kids, then the dispositive document says, here's what I want you to do. I name, brother and sister to become the guardians, to take physical custody of the kids and raise them. And I also give you all the money, whatever it might be, life insurance proceeds and proceeds from the sale of the house. Hold that in trust for the kids, use it for their health, education, maintenance, and welfare during their minority. And when they reach certain ages, you can start giving them their stuff if there's any left. So you can do that in a trust or in a will. I like the trust better because obviously it's quicker, faster, cleaner, and you avoid probate.
Is there any tax benefit to a
Oh,
trust?
tax benefit. A revocable living trust, no, none. Because you control it. And although the law allows you to engage in this legal fiction of, I don't own the property, my trust owns the property, the IRS is not a big fan of that when it comes to taxes. So if there are any tax issues with regard to a trust, they're going to be the same whether you have a will or a trust. But what are the tax issues, right? And typically when we talk about someone dying, we're talking about estate taxes. So the estate, in order to start incurring estate tax, an individual has to have an estate that has a value of $11.5 million or more. A couple, $23 million or more. So most of us don't have to worry about estate taxes, 99%, right? So there shouldn't be tax issues with an estate, whether it's a will or a trust, unless you have, I suppose there could be rental properties that are held and you may have capital gains taxes when they sell. Those will be the same in a will or a trust. I hope that answers the question.
One more question. So in that instance, is all the money for attorney's fees and other fees coming from the estate while that is getting figured out?
So on the probate side of things, yes. And because attorneys have a fantastic lobby at the state legislature, we are a priority claim against the estate. So yeah, but the estate can pay attorney's fees out of the estate if you need to go to probate. On the trust side, there's no, the expense that people incur is really upfronted on the trust side. They typically cost a little bit more, not a lot, but a little bit more than doing a will. But then afterward, there's no back end cost like there is with a will when you have to go to court and have it probated. So, but yeah, even in that scenario, any trust that I create or typical trusts that are out there allow the successor trustee, which is what you call the person under a trust, just like you call a personal representative under a will. They can get compensated for anything they might need to do from the trust.
No other questions.
Cool. So the next way, the next transfer upon death, we're still there, is a joint tenant, right? So we're getting to that clear, easy, and simple upon the death of the first joint tenant to die. It transfers immediately to their surviving joint tenant. No need for probate and anything like that. So that's the most common method of holding title here in Colorado or elsewhere where you have more than one owner. So those are good. And we talked a little bit about tenants in common, right? So that's where you each have an undivided specified interest in the property. And what happens upon death when one of the tenants in common dies? Well, your tenant in common can be a trust. So a trust can be one of the tenants in common. If a trust is a tenant in common and someone that's involved in that trust or created that trust dies, then that interest goes pursuant to the terms of that trust, and there's no need to probate their interest, even though it's a tenant in common. If it's not held in trust, then that share of the property, that tenancy in common, would need to be probated. So those how those transfers occur upon death. So let's talk. Is there another question? I just see something pop up.
Yes, a joint. Is it best to record the death certificate? I recently asked a title company and they told me they would just do it at closing.
Okay, yeah. So here's what happens. Well, that's true. But what if, say we have husband and wife, spouse number one dies, spouse number two lives for another 40 years, okay, and then dies. And we need to show the title company that spouse number one's dead. Do you still have the death certificate after 40 years? It's probably best, safest practice to record a death certificate upon the death of one of the tenants in common, whether or not you're going to sell that property right away or not. Just record it. It's in the chain of title, and you don't have to go digging through drawers, 30 years down the line to find the certificate.
It's a mother's son. The mom passed away a year or so ago.
Okay, and if the son is selling the property and the son has the death certificate, yeah, and the title company says we'll just do it at closing, that's fine. Let them handle it. Should be fine. So transfers in anticipation of death. So how do you transfer your property before you're dead, right? We talked about a couple of these ways already. One is through your will. I leave my house to, my spouse if I die, and if my spouse isn't around, I leave it to my kids, and if my kids aren't around, I leave it to my attorney. No, the Wild Bird Foundation, whatever it might be, So there are a number of ways you transfer your property in anticipation of your death in a will, and you can be as creative as you want. But remember, when there's real estate, or alluded to one of the other triggers, property in excess of $68,000. Okay, who values that? Well, nobody. So typically, that's not going to become an issue unless it's something like story number 4. I've got a case where mom dies in California, has no probatable assets in California, but has a bank account at a credit union in Colorado worth $75,000 and no pay on death designation of beneficiary. Probate time. So we've got a an asset clearly in excess of $68,000. It's not real estate, and we have to open a probate to have one of the kids appointed personal rep so they can get the money. So another trigger there. So there are ways that you can transfer your property in anticipation of your death. I always tell people, whatever they do, whether it's a will or a trust, those unusual or assets you don't really think about much. Everybody thinks about the house, right? But that savings account at this credit union, you need to make sure you go in there and do a pay on death designation of beneficiary. You need to make sure your life insurance policies, your designations of beneficiary are up to date, things like that. So I digress. Another way to transfer property in anticipation of death is to add an intended beneficiary just to the title of your house. And believe me, as well, maybe it doesn't sound crazy. It sounds crazy to me, but you wouldn't believe how many people have done this and want to do this. Because if you put kids on as joint tenants and you die, okay, there's no probate, right? I've dodged that bullet. But boy, oh boy, there's a lot more bullets that can be coming at you in the interim. For example, mom puts son on as beneficiary because this is her estate plan. This is how I'm going to do it. Son's, a nice guy, but not very good with money. Gets into a lot of debt, gets into some business transactions that go south, has a ton of creditors, and files bankruptcy because there's no other way out for son. So the bankruptcy trustee, the bankruptcy court appoints a person called a bankruptcy trustee. The job of the bankruptcy trustee is to look for any assets that the person who filed bankruptcy has that are not exempt from the bankruptcy trustee getting, and get those assets and sell them or do whatever they want to pay off some of the creditors. Well, guess what son has? He's got an interest in property. Okay, so depending on one of the cases I had, mom had a property worth about $500,000 and no mortgage. And the exemption for the trustee, mom, the tenants get to keep, I think at the time it was $60,000. And the bankruptcy trustee gets the rest. So mom's out of her house. Son was never really in the house. Bankruptcy trustee sells the house, and there you go. That was a good estate plan. Other thing that could happen, even if your kid or kids are fantastic, my son's a doctor. Does he drive a car? Could he potentially run a red light and hit somebody and kill him and be involved in a personal injury lawsuit? And again, the attorneys are looking for assets, right? What does this person have? Oh, you're on deed to a house. So same kind of thing. Never add an intended beneficiary to the title of your house as your estate plan, and that can be a real problem. The other thing is this beneficiary deed. So now I'll unveil the concept of the beneficiary deed. Okay, so this is a deed, special deed created by statute in Colorado that allows you to designate someone to get your property when you die. You don't get it before, you only get it when you die. They're not on as a joint tenant, so you avoid all those problems that I just talked about adding your kid as a joint tenant. But here are some of the downsides. Upon the death of the grantor, the person who put them on the beneficiary deed, the beneficiary doesn't immediately receive marketable title. And in fact, there's a claim period that it can be in effect for up to 3 years. And because you don't probate it, you don't get one of the benefits of a probate is you get to cut off that claim period. But here you may have to wait up to 3 years really to see if creditors are going to come after and make claims against the property. If you have a beneficiary deed, you know, mom puts son on the beneficiary deed, mom goes into a nursing home and, you know, needs assets, applies for Medicaid, you will not get Medicaid if you have a beneficiary deed where you've given interest in your property to someone else. So mom or whoever the person, you know, giving the benefit to the beneficiary may be ineligible for those benefits. If you name multiple beneficiaries, um, the deed gives them equal rights, so that when the grantor dies, those beneficiaries have to decide and agree to what happens to the property. So you name 3 people, 3 kids. You know, 2 kids say, let's sell this thing and be done with it. 1 kid says, no, let's make it an Airbnb and you know, rent it out and make a bunch of money. Okay. What do you do then? Well, you call a lawyer and you go to court and you incur a lot of money to get that resolved.
So
And
with regard to the car accident, sorry.
oh yeah,
So does the trust protect anyone from coming after the house in that car accident situation?
it's harder to do. It's not a slam dunk winner, but it's harder to do because of the fact that this legal fiction exists that you don't own the house, the trust owns the house, right? But they can, clever attorneys, I don't know any of those, but clever attorneys can make the argument, just like the IRS does. Wait a minute, may not be in your name, but you have total control over this, so it's really your thing, this house. So yeah, it can still be a problem, and there's a simple answer to those issues, and that's insurance. Make sure you're heavily insured. So because Frank Azar, I'll be looking for $2.3 million from you.
So
Anyway.
Beth Ann made a comment saying that she had a situation with beneficiary deed, and the title company they dealt with required them to wait 120 days from death, and they accepted it. So they were able to close in 3 months to avoid probate.
Yeah, you avoid probate, and there are certain classes of creditors who can still file claims up to 3 years, but creditors like lien holders, mortgage companies, they've got a 4-month window to make sure their interest is recorded. So that's where that 120-day comes in. But yeah, it can still be problematic. And if you change your mind as the creator of the beneficiary deed, which you can, you've got to have a revocation deed prepared and signed and notarized and recorded. It's kind of a pain in the butt.
Okay, so we're at halfway point.
Okay.
If we wanted to take a break, we currently have 11:08. So if you want to come back at 11:18, we will get back to it. And so do what you need to do. We'll see you in 10 minutes.
I'll stick around. If anybody has questions, you can feel free to ask questions. Yeah, and anything. It doesn't have to be this subject.
Vince,
Yes.
this is Penny Verdulovich. Now, I've had beneficiary deeds on all the properties that I own. Everything's free and clear, and I'm giving them to my sons. Beneficiary deed, 2 sons, 50% each one. Is this the best way to protect them from having to deal with probate and taxation and everything? Or is there a better way to do this?
Well, being a fan of the living trust, I always think the living trust is the better way, because let's say, so here's how it works. You create this document called your living trust. It disposes of your stuff when you die. It addresses houses and all kinds of things. And then you deed those houses into the name of the trust. So Penny doesn't own the property. The Penny Living Trust is now the owner of the property. If you want to make changes, you only have to make changes to your trust document, an amendment to your trust. The trust document is considered a contract. It doesn't have to be signed off on with the same formality as a will does. easy to make changes to your trust document. So that's how you can make those changes. If you want to make a change and you've got beneficiary deeds, son number one makes you angry and you say you're getting 40%. Now you've got to revoke it and do a new one, and it can be problematic. And for the other reasons I talked about. I just like the clean simplicity of living trusts.
I have a living trust. Maybe I should go and review everything. It's been probably about 4 or 5 years since I had new trust documents drawn up. But I have a living trust and I have beneficiary deeds. Do they work together, or?
No, they don't.
One or the other?
Typically, yeah.
Okay.
So yeah, it's usually one or the other. And if you've got a living trust and you like that, you can quit claim those. You first have to revoke the beneficiary deed, then you have to quit claim into the name of the trust. So
okay,
that's one way to go.
All right, thank you.
Yeah.
Oh, are there tax benefits? How is the property taxed once I'm dead? Kids have it. Do they have to pay any taxes, or just the regular property taxes when they do?
Yeah, there's no inheritance tax. These things pass tax free to the beneficiaries. The only potential tax is the tax on the estate that we talked about, but the exemptions for that are so high that most people fall outside of those.
Okay. So living trust. All right. I will get that taken care of.
Yeah.
Thank you.
You bet.
Vince?
Yes.
My name is Misty and I own a property management company. What do you like to see property management companies receive when a tenant dies and somebody is coming to try to collect their personal belongings?
Yeah, that's an interesting thing because, you guys are holding the property, and under the law, we call that a bailment. So you're holding property for really the benefit of another without an agreement as to what to do. You need to be sure that the person you release that property to has a right to receive the property. That can vary from situation to situation. First, you want to ensure the person's dead. So a death certificate's always good, right? Unless they died in the property, then you have a whole set of other problems. But yeah, you want to make sure that they're dead. And then if someone's coming in saying, I want this property, I'm the son. Well, how do you know there's not a daughter or another son, or
right?
Who knows? So yeah, I think at that point in time, you need to make sure they either bring you a will, or if they've been appointed, if they're renting an apartment, they probably aren't going to be in a probate situation. They might not have any of those triggers that put them into probate.
Correct.
Yeah. You'll need to make sure that you have identified all of the people of the class that might have claimed the property. So usually if it's a parent, it's the kids, right? If it's somebody without a family, you've got a whole set of other circumstances.
Would a personal representative deed suffice at that point for us?
If you've got somebody appointed as a personal representative of the tenant, I don't know why you would, unless they had other property that needed to be probated. But if you do, that person has the ability to manage the entire estate of the deceased. And yeah, you are absolutely safe. Get a copy of the court will issue these letters of appointment or letters testamentary, depending on whether there's a will or not, no will. And there'll be a court seal on it still. They have still pressed the old fashioned seal on them. Make sure you get a copy of that. So.
Okay. All right. Thank you.
Mr. Buzek, Alex Strauss here again.
Yes.
I have another question, maybe unrelated. What happens in a case that one of the spouses got sick and passed away, then there are still medical bills related to the disease? Is the second spouse still responsible for these medical bills? And if yes, can the creditors then go after the estate that has been left after one of the spouses passing away?
Sure. So typically in a situation where you've got a surviving spouse, most assets are going to pass by operation of joint tenancy, those concepts. And so the surviving spouse will take over everything. In terms of the debt, if there were medical debts or things like that, that depends on a lot of things. That depends on whether the surviving spouse signed off on any documentation of the medical providers authorizing, accepting responsibility, or there's also this family obligation doctrine in Colorado that debts incurred, by spouses during a marriage can be considered familial debt, and a surviving spouse may be responsible for some of that.
So that would mean that the medical bills, so even if one of the spouses passes away, the medical bills are still in place and they have to be paid back.
It could very well mean that, yeah.
Okay, thank you.
Vince,
Yes.
this is Penny again. I just looked through all my documents and I have a revocable trust. I thought I had a living trust. So I should go back and have
The
a
same
living
thing.
trust.
It's the same thing.
But
So
I had the beneficiary deeds.
yeah. So a revocable trust and a living trust are the same thing. The correct name for it is a revocable living trust. So the concept of making it revocable means you can change it, revoke it. It gives you total control, and you always want that, right? The alternative to a revocable trust is an irrevocable trust. I alluded to that a little bit, and those are
Right.
They're problematic in a lot of ways.
But with the beneficiary deeds, those have to be revoked if I'm going to.
Yeah. There's a specific format for doing that,
Okay.
and getting it recorded, and then doing a quitclaim deed into your trust. I mean, if you paid good money to have your trust created, probably a good idea to put the real estate in there as well.
All right. All right.
All right, everybody needs to start coming back, getting your cameras back on. It is officially 11:18. So we're going to do our attendance check-in one more time. Do your first name, your last name, and your email in the chat box to let me know that you are interested in that 2 CE credits. Take it away, Mr. Buzek.
All righty then. So, oh no, I know you guys love my stories, so I missed one. So when I talked about adding an intended beneficiary to your deed, I talked about bankruptcy, talked about the personal injury lawsuit. Here's another one, another case from my files. Mom and dad add daughter to the deed as joint tenant because that's their estate plan. Mom and dad have a falling out with the daughter. They're not getting along too well. Mom and dad want to move from Colorado back to, I don't know where, Iowa, I think, and want to sell their house and use the proceeds to buy property in Iowa. Daughter on the deed says, or if you do, I want my inheritance now. So that's a problem. Just want to throw that one out there as well. Don't add people to your deed. That's the lesson. All right. So how do you protect your real estate asset after you buy it? And we've alluded to a lot of this stuff, and it depends what your level of comfort is, I suppose. But everyone should have some kind of a dispositive document, something that says, here's what happens to my stuff when I die, whether that's a will or a trust. Because if you don't, you're just leaving a lot of things up in the air for other people to figure out. And, those are the people that come to me with a shoebox full of stuff and say, well, what do we do? So that's not an easy thing. If you've got a will, we talked about that. It's good. Talks about what you want to have with your stuff. It can talk about minor kids, who's going to take care of them, who's going to manage those money. It can talk about all that stuff. But obviously, as we've talked about a lot here so far, is if you've got real estate or other assets, you may need to go through that court probate process to have someone appointed as the personal rep to give effect to the will. And that's the job of a personal representative. In its simplest form, they get the will, they read it, and they do what it says. Simple. Trust functions in a lot the same way, although we don't call that person in charge after you die a personal representative. We call them a successor trustee, because when you create your trust and you put all your stuff into your trust, it's called funding the trust. Most critical part of a trust. If you don't have your stuff in the trust, what's the point? We don't name that person the personal rep, we name them successor trustee. So same concept, you're gone, the people that created the trust, the original trustees die, the trust will say when that happens, that's a triggering event to start shutting the trust down, usually, and here's how we distribute the assets of the trust. And the person who's going to do that is our successor trustee. Same thing, what's their job? Get the trust, read it, do what it says. Much easier job for them because they're not going to court to be appointed, and getting involved in that process, and they can put the property on the market for sale the next day. Usually when you do a trust, your attorney will prepare something called a memorandum of trust, which is usually a 1 or 2 page document, which is just a consolidation that says, I created a trust on this date, we're the trustees, and when we die, we name this person to be our successor trustee. Real summary kind of a document. Sometimes you don't do that. You have the trust document. So when you go to a closing or you contact a real estate agent to list the property and you're the successor trustee, they're probably going to want to make sure you have the authority to list this property. So that's where things come in for you guys. You've got to either have letters of appointment from a probate court appointing them as personal representative, or a memorandum of the trust, or a copy of the trust document that says they're the successor trustees and they are then authorized to sell the property, because you don't, well, that's kind of a fundamental thing when they're signing their agreements with you, right? So obviously, we talked about the issues of probate and what can happen. Trust, again, fast, easy, and generally not a lot of complications, because you've eliminated the opportunities of contest that there can be in a will situation. You've already transferred the property out of your name, so there's no probate that's going to come up, and it's quick and fast, and typically no cost after you die. Often I'll have people call me that I've done a trust for their parents or whatever, and say, mom and dad have died, what do we do? I said, what do you want to do? If you want to sell the house, sell the house. You can do whatever you want now, unless, in keeping with the intent of the document. So, and when you die without a will, we talked about that intestate succession. That's when you're probably still going to court if you've got a house or property in excess of $68,000, and then you have a lot of issues potentially from who's going to be the personal representative to how whatever they have is going to be distributed, to how you close things out, how you value things. You get in the will situation, you can get a lot of arguing over a lot of stuff. Sometimes things that don't seem to make sense to you make sense to the heirs. So those are the typical ways that you can protect your real estate assets. No will, okay, you're going to probate. Will, going to probate. Trust, no probate. So again, I think I've harped on that enough. It's really fast and easy and clean. And who's the woman on PBS? Susie Orman. You guys, flick the channels around. And there's every Saturday morning Susie Orman is online on PBS talking about everybody needs a living trust. Of course, she sells them too, but that's another story. But I agree with her in that regard. You need a living trust. How do you, let's talk a little bit about that. You can go online and do these things. Good luck.
That's the next question. Are online methods of setting up living trusts sufficient? And a previous question was, how can we check how title is held?
You can check how title is held by contacting your friendly title company and asking for an ONE. And they usually charge $5 to do that. So title companies are fantastic for that, because that's always, whenever I have somebody come in to do estate planning, I demand to either see their deed, go back into the bottom drawer in the kitchen and get that big folder out that has all your stuff in it and show me the deed, because I need to know, not only do I need to know the legal description to do a quitclaim deed, I want to make sure that what you're telling me is right. You can't find that. Next call is to the title company. I need an ONE, and here's the address, here's the names. Boom, it's done. So that's
Are
good.
online methods of setting up living trusts sufficient?
No. Next question. so there's I'm learning things all the time after 33 years of practicing this kind of law. If you think you can go online and press a button and what does it mean when I leave things per capita versus per stirpes? What does that mean? I mean, you've got to make a lot of decisions, and an attorney can guide you through that. The job of an attorney is to answer those questions and make it as easy and understandable as possible. There are all kinds of these. There's a new one. What's it? Wills and Trust. There's some new one that I hear advertised lately, and it's just great. Well, yeah, until you die, and someone needs to pull that thing out of the drawer and give effect to it.
Well, that speaks exactly to a real estate transaction as well. Do you do for sale by owner, or do you have a real estate agent, and why? Because it is our job.
Yeah,
More versed in what's going on.
Exactly. And absolutely, you all, yeah, for sale by owner. I knew a realtor, and he coined. I give him credit, but who knows? He always says FSBO stands for finest source of business opportunity, because it's hard, and you guys are trained and have experience. You know what you're doing. You know what the pitfalls are. And typically, I think statistically, when you list through a real estate agent, you get more money for the sale of your home. Of course, in this market, I don't know. It's just crazy, but we're in a crazy time. But generally, I think that is absolutely true. You get more. I will never not use a realtor if I sell a property, even though I think I know stuff. I don't know everything. So anyway, yeah, same kind of thing. Yeah, the online things that I find problematic, because estate planning can have some complicated issues. How do I, I'm remarried. I have kids. My wife has kids. How do we work that out? What's a good way to make sure nobody feels like they're getting, I mean, what box do you click online for that one? I don't know. So anyway.
Couple more questions.
Yeah.
Do you only do real estate trust planning, or do you do general real estate law?
I do general real estate law as well. And you will get my most recent story about that in just a moment.
All right. Next question is, what is the average price for a living trust?
Depends where you go. So there are a couple of law firms in the Denver metro area that hold themselves out as, this is all we do. One of them is, does anybody get the Sunday paper anymore? They have the little yellow rubber duck, and yeah, they have take out full page ads, and their trust will cost you, I don't know, $15,000. Yikes. I charged a flat fee of $3,500 from start to finish, including the deed work and the recording of deeds and all that stuff. It includes everything, right? So here's things that you'll need to know. When you do an estate plan, there's clearly the dispositive document, the trust document or the will document. But that's not all an estate plan needs to consist of, okay? We talked about powers of attorney. You need a financial power of attorney, and you need the most important estate planning document you will ever create, the healthcare power of attorney. And believe me, that's I like living trusts and all those things, but those talk about what happens when you die. Healthcare power of attorney talks about what can happen while you're still alive, and hopefully get you to a point where you're gonna be okay, right? So most people think I'm going to name somebody to have medical decisions for me, healthcare power of attorney, so that when they come in, they'll need to know when to pull the plug and not pull the plug. My God, that's not the most difficult healthcare decision that an agent makes. They'll make quality of life decisions. They'll make all kinds of decisions. So I always say, boy, oh boy, that's your most important document. Make sure you have that. Make sure that when you name that person as your agent, you sit down over a bottle of wine and talk about what you want to have happen in different scenarios, because you can't put them all on paper. A million things can happen, right? Okay, so you got your dispositive document, financial power of attorney, healthcare power of attorney, and a living will, which whoever named that, I would love to just clock them, because it has nothing to do with the will. A living will is more like a healthcare power of attorney. It envisions a scenario in which there is no one stepping forward under a healthcare power of attorney. A lot of things have happened to you medically. You're basically getting ready to check out, and you can't communicate your wishes. And a living will is a directive to a healthcare provider that if I'm in your hospital, in a bed, in a coma, getting ready to die, here's what I want you to do, healthcare provider. Pull that stuff off, and then I'll make a separate designation about what I want you to do with tube feeding and IVs, if those are in place. Living will is the, that what if, important to have nonetheless. But so in a trust side of things, you've got actually one more document, and people always are confused when I tell them this. You've got your living trust document. You've also got a will. But wait a minute, I thought wills are bad. Yeah, they are. So when you have a living trust, you have a special kind of will. It's called a pour, P-O-U-R, pour over will. It's a catch-all. It's if you have something that's not in the name of the trust, it says put it in the trust, and that's how I want it disposed of. So if you've got whatever it might be, you've got a gun collection, and the trust doesn't say a gun collection. Your pour over will say anything else that's not in the name of the trust. That's how I want my stuff to be disposed of. So you have a will, but it's a special will. It doesn't get probated. So that's the package that comes with a will and the package that comes with a trust. So yeah, prices are all over the place. I mean, I've seen them as cheap as $1,500. I don't know if that includes, and as high as $15,000. But when you do the $15,000 one, you get a nice 3-ring binder to put everything in. So you do get some benefit. I shouldn't be so. That's kind of cynical. Anyway, do we have any more questions before I move on?
You're good.
Groovy. Okay. How does estate planning protect your real estate asset from all these things? So we talked about, I'll go down to the third one, probate, right? So yeah, your living trust will take care of that, provided it's done properly and that it's funded properly, right? You do that quick claim deed, make sure you do that, put it in real estate in the name of the trust. Claims of creditors, yeah, so there are certain classes of creditors that are always going to have viable claims, whether you're in a will or a trust. for example, the mortgage on your property. I can't tell you how many people call me and say, I just inherited my parents' house. Do I have to pay the mortgage? They somehow think that they get this property free and clear of everything. And unless you've got special insurance policies that have paid that off, no, you've got to pay the mortgage. When you die with a will, there's a requirement that you publish notice to creditors, right? So if there are unknown creditors out there, they can read the legal notices in the newspaper, with their magnifying glasses because they're so tiny, and they might file a claim against the estate. And believe me, I've had creditors say, "Oh, hey, I saw that Joe Blow died. He owes us, $1,000." So yeah, that can happen. When you die owning a trust, you don't need to publish notice to creditors. If you know of creditors, there may be a requirement that they get paid, but unknown creditors, you're free and clear of those claims. Again, we talked about financial problems of your beneficiaries, right? Don't put their names on your deed. Don't do that. So make sure you don't do that. Claims of heirs and relations. So when you're in the probate system, I alluded to this as well, you've got this class of people called interested persons. And interested persons are broadly defined as heirs and potential heirs. It's a broad group of people, and the probate code gives them certain rights. I want to see the will. I want to know what's going on. I think I should have been in that will. They promised me that when they died, I mean, I've had all of these kinds of things come up over my career, and some of them you just wouldn't believe. Like, really? But yeah, really. So estate planning is a really good method of protecting the real estate asset. And because it is generally the biggest asset that people own, it really should be something that gets addressed. And you guys as realtors, important, your clients buy a house, they got this new shiny house, it's great. Make sure they've got it protected. Have them call somebody and ask some questions. So
Got a comment.
Yeah.
I don't mind leaving my normal assets to my sister and my niece. I don't know what to do with my business, though. I know I need to do something, sounds like a trust. My problem is who to leave it to, because neither my niece nor my sister are interested, and honestly wouldn't know what to do with it. So no spouse, no children, and dogs aren't going to be help either. Any thoughts?
Okay. So the business is the business. There are a number of types of businesses, like professional, like mine, that has zero value without me. Right? I mean, and we've got some ethical prohibitions from selling a business also, but there are a lot of businesses that have no value when you're gone, because you're the asset, you're the business. There are other businesses that do have value, businesses that have inventory and goods and stock and things like that. So it depends on the type of business, but you can always say, with regard to my business, here's what I want you to do. Sell it off, go on a vacation.
Can you unmute yourself and let us know, are you a realtor and you're talking about your client database?
Hi, Vince. It's my question.
Yeah.
Yes, I am a realtor and I have a team and another one getting ready to start. I have the database and I have some things in place that people want to stay with the team. I mean, if I'm not here, they plan to keep going forward with the name and the brand. But I really don't know what to do with all of this. And I'm like everybody else. I really don't want to think about it, but I know I need to.
Yeah. So the first question I would have is, are there any legal or ethical prohibitions of transferring that asset? Do you owe anyone an obligation or a right of first refusal, things like that? So if you don't, and it's your stuff and your asset, then the question becomes, what would happen if you're alive and you just want to sell? What would you do? Is there a process by which you could make that happen and acquire value for it? If that's the case, then it's a valuable asset, and yeah, you can direct in your will or your trust. Yeah, I direct my successor trustee to, you know, hire business broker ABC and Company to sell the asset or whatever, and then with that, the value received, put it in the trust and distribute it as I say. And here's how I say. So yeah, business assets are always tricky because just Becky, like you said, then your family's not going to want to probably step in and run the business.
They do not.
God, who would want to run my business? I don't even want to run my business. But yeah, so that's always a problem. But if it's a business that can have value that you could sell while you were alive and recognize some decent value, then yeah, you should address it in your estate planning document and get the value and do what you want with it. Either give it to family or donate it to I've got a number of clients that they have no family and they just want to leave it to the Wild Bird Foundation and the Butterfly Pavilion. And
Okay.
and that happens a lot and those entities are thrilled. So
Sure. Okay.
yeah.
Thank you.
Yeah,
It
you
sounds
bet.
like if she has a team, she's at least has somebody that could then take over, right?
I do.
Yeah, so yeah. Okay. There can be some planning you do prior to your death with regard to that. So okay. So let's see. We talked about how estate planning. We talked about that. I alluded to the will contest I had in Arapahoe County 2 years ago now, since everything was paused last year. But yeah, so estate planning is really important and can help you or your clients avoid a lot of pitfalls. All right, real estate contracts, buying or selling property in probate. Okay, so if you've got a property that's in probate going through the process, you've got to wait for a couple things to happen. As a realtor, you've got to wait for that person to be appointed as the personal representative, right? Because that empowers them to sign your listing agreements and to sign contracts and to sign deeds. So without that, you got to wait. So my case in Sterling, we've got to get through the fight of the 7 siblings to see who becomes the personal representative before anything can happen to this property. So make sure you do that. Make sure you've got, who you're dealing with and that you're dealing with the right person, right? So that person has the ability to sell that property, keep that property, retitle it into, whoever is supposed to get it pursuant to the terms of the will and so forth. You've also got this claim period, right? So it's a minimum of 4 months from date of first publication in a newspaper, right? So arguably, you shouldn't sell the property for 4 months because somebody could file a claim that could affect the proceeds from, say you wanted to sell the property out of the estate. So yeah, it can slow things down a bit. That alone can slow things down, let alone fights over, siblings over who's going to be the personal representative. There's also this issue of seller's disclosures. What happens when you have a client come to you and they want to sell a property that's in probate? They've been appointed the personal rep. You have them fill out the real estate contract in paragraph 10. Says the seller's going to make seller's disclosures and disclose known latent defects and yada, yada, yada. So your seller's got to fill out a seller property disclosure form where they list any latent defects actually known to them. So what does that mean? I mean, so often your client, the heir of the owner of the property, may not know anything about that property, but they're not exempt from filling out the seller's property disclosure. So do they just check don't know on everything? Well, maybe, but maybe there are things they do know about. And, maybe a neighbor has said, oh, you're selling that property. Good thing, because man, that basement floods anytime it's foggy outside. So, you know, there can be all kinds of issues there. In the very beginning, I alluded to a case that I just got done with in Fort Collins, a week-long jury trial that arose over issues in a seller's property disclosure. Now, this was not a probate case. This was not something that came out of probate, but the principles are the same. So, you know, paragraph 10.1 of your form real estate contract and 10.2 talk about seller's property disclosures and disclosing known defects. And the seller's property disclosure form talks all about the things that sellers should be disclosing if they know about them. So I'm going to turn my camera just a bit to show you the result of not filling out seller's property disclosures properly. Those are the files, my files, that I had to take to Fort Collins to try a case. And in this case, I represented buyers of a fix and flip. And the owner was an investment company, sole owner, that fixed and flipped. The problem in the transaction was the fix side of things. So a lot of defects that this seller knew about and concealed, and my clients bought the property and shortly thereafter began finding all kinds of issues. And these are issues that were not apparent in the inspection. So everybody, right, we all, well, anymore, I don't know, but in the oldie days, there was always a property inspection, right? I know now that there are transactions happening without property inspections, to which I say, wow. But, you know, people want houses. So this one, right, there was an inspection and a number of things were discovered, but we later discovered that structural walls were moved and, you know, there were wires buried behind walls that were live and not capped off or not, you know, put in an appropriate junction box or whatever. I mean, there are all kinds of things. So anyway, I digress a little there, but just to let you know, even in your regular practice of real estate not related to probate, property disclosures are pretty important. And here's the one thing, and I have to say this because I guess I never took a very hard look at the Division of Real Estate form until this jury trial. So there's this section on the last pages, right? It's the advisory to the seller and the advisory to the buyer. Seller's advisory basically says, make sure you fill this out properly because there could be legal consequences if you don't. The advisory to the buyer, which is 7 paragraphs long, says all kinds of things. You know, you might want to look at this and you might want to look at that. And you should consider this and you should consider that. And the one paragraph that I think kills me, I don't know how this happens, but you guys tell me what you think. It says buyer acknowledges that seller does not warrant that the property is fit for buyer's intended purposes or use of the property. Well, what are they buying? They're buying a house. And this seems to say might not be fit to be used as a house. So make sure when you're on the buyer side, make sure your buyers really understand what this disclosure, because this came up in our trial and they tried to make the argument, seller, that I never guaranteed this was going to be fit to be used as a house. Well, the jury didn't like that, but it says what it says, and they could have liked what it said, I suppose. But just remember that when you guys are out there filling these things out and you're representing buyers, representing sellers, there are significant impacts, and drives home to me the need for a really good property inspector. And I know you guys have your industry partners, and I know a number of them as well. And there's some really good people out there that do a good job and a thorough inspection, and not just to, you know, yeah, it looks good. This property had a septic system my clients, the buyers, didn't have a separate septic inspection done. Mistake. They also did not investigate whether permits were pulled for this extensive renovation work. Mistake. So when you have clients in the situation, you're buying fix and flips, sometimes some renovations don't require permits. Got it. I get it. When you move structural walls and do some significant rewiring, you change out HVAC systems, there are a lot of things that even if a homeowner does, permits are required. So as part of your due diligence, if you represent buyers of properties that represent themselves as complete remodels or whatever, just go onto the county website and see if when the last time permits were pulled on the property. And at least you can tell your buyers, I looked and there were no permits pulled. This may be a consideration for you. So yeah, this was a big thing. And why is it this came up in this case too? Well, what's the big deal? You pull a permit, you don't pull a permit. So what? What's your damage? Well, when you pull a permit, what comes along with that is somebody from the county coming out to the property to inspect that the work was done and done according to code. You don't have that, So now my clients, are what's behind those walls? What else is back there? So, anyway, that's kind of an important consideration on these fix and flipping things, right? So, but anyway, taking a property out of probate, yeah, make sure you got the personal representative appointed. It's going to take some time. There are going to maybe some delays. Worst case scenario, somebody dies in the middle of it, right? You got a client that you're selling a piece of property for and they die. That's not good, right? So that's going to throw things, a monkey wrench into things. How about properties held in a trust? Well, the role of the trustee, or what's really technically called the successor trustee, is the same as a personal representative. Get the trust, read the trust, do what it says. So we talked about the upside. The upside is I don't have to wait for the court to tell me I'm the trustee. The document tells me I'm the successor trustee. It's a contract, and contract law applies. So I can act immediately. I can make things happen. My heirs and beneficiaries that I'm doing this for are going to realize the value of the estate immediately. So obviously the successor trustee has to do what it says. They can't just, unless there are some trusts that I've seen out there that say, whatever my successor trustee decides to do with the property, good with me. I don't think I'd draft that, but it can happen.
Question.
So, yeah.
So how did the seller's property disclosure end up?
You win some and you lose some. And in this case, we won some and lost some. So we had some claims we prevailed on and some claims we didn't. So it was technically a construction defect case, right? So we made arguments of negligent construction. Okay, that puts you into the statutory framework of the Construction Defect Reform Act in Colorado. Okay, negligent construction, fraud, failed to disclose things you knew about, you lied, fraud. Breach of contract, you are required, the seller's property disclosure is a part of the real estate contract, and it required you to disclose these known defects. Didn't, breach contract. And do we have another claim? Maybe. So we prevail on some, not on others. And so, some of them were kind of weird issues, but it was a jury trial. And I've often said, the outcomes of jury trials can be easily predicted with a coin. Just toss it, and you'll probably figure the outcome out that way. Because juries are going to do what they're going to do. They're going to like what they're going to like, not like what they're going to like. Maybe they didn't like a tie I wore one day. I don't know. But so anyway, my clients got some relief, not all the relief that they hoped for, and lesson learned for them and for me. So, and hopefully for you guys, seller disclosure is a big deal, and inspection's a big deal. And when you have these fix and flips, maybe you want to have your clients or you, whatever you want to do, just check and see if permits were pulled. Just give them the info at least, so they're fully informed. Okay. So what is the impact of property on the timing of the closing? And like I say, you're typically going to wait that at least that 4 months from date of first publication to creditor notice time frame before you sell. Can you sell it before that? Well, yeah, you can. You can sell it and hold the proceeds just in case. You can sell it. Your personal representative can sell it and can distribute the proceeds if they're feeling lucky. But you probably want to at least hold those proceeds, and maybe even I would maybe even wait to list the property, sell the property, just to be safe. So those are some pretty important things. What happens, once the personal rep is appointed, they can do what they want. The biggest impact is, what happens when you have a seller that dies? I don't know, has anybody had that where you've got a seller that died in the middle of the transaction? Yeah, it's an unusual case, but I'm certain it's happened. And then, I think the biggest impact is going to be on timing. And it may be, if you've signed a listing agreement with the deceased, the question is going to be how valid is that, after their death? Probably not. And if the personal rep wants to use someone else, are they obligated to use you? Do we have this procuring cause issue that comes up? Yeah, maybe. So it can complicate things in any event. And obviously, when you have a trust, yeah, timing right away. Trustee's authority, immediate. Trustee's deed, yeah, usually title companies prepare those. It's funny because when you have a property in probate, we, the attorneys, are the ones who typically prepare the personal representative's deed because it asks for stuff like the case number and the date of the death and stuff like that. So it asks for things that I suppose we have easier access to, but attorneys usually will prepare the personal representative deed for the sale transaction. I've usually had title companies prepare the trustee's deed. It's just a different kind of deed, so it's not a big deal. So trust, obviously, and again, still the better way to go for timing, speed, and ease. How about properties held in other manners? We talked a bit about this throughout. You've got tenants in common. Okay, yeah, it depends who the tenant is. If the tenant is a trust, then you've got just the trust issues, that same as before. If it's a person, then yeah, you're going to be probating that person's interest in the property to give effect to what happens. So there can be timing issues just like the other ones, and there you can look at the rights of the other title holders may have an impact as well. So like I alluded to before, sometimes you have these tenant in common things where there's a vacation property that 3 families own, right? I gave that example. Sometimes they have cohabitation agreements. They have all these other things that go along with it. And there can be sometimes conflicts between the deed and the agreement. And then the question is, what prevails? So there you go. That's in essence the presentation. I think we're at the 2-hour mark. I'm happy to take questions, try to give answers, and let me know what you think.
Sorry, I was talking with my mute on. Question, why do some take 4 months and others take 3 years?
The probate stuff. So some of them take 3 years if there are disputes over claims of the creditors. So right, you've opened yourself up to these claims and unknown claims, and you can have a creditor that comes forward and says, I've got a document here, a promissory note that the deceased signed 10 years ago. They're going to pay me $50,000, and the role of the personal rep in the estate is not just to write the check. You got to make sure it's a valid claim. And so there have been cases where you've got issues with claims of creditors that can tie things up and muddy the waters for a period of time. You know, you're working to negotiate the claim. Sometimes the claim ends up in litigation. So there can be a lot of reasons why. That 4-month thing, that's the minimum time frame from date of first publication to creditors to end of that, cut off that period, that you can process the estate.
Okay, it is officially 12 o'clock. To be respectful of people's time, one last time for check-in on attendance. If you would like the 2CE, please put your first and last name and email in the chat, and we'll be sure to get that attestation form out to you via email. But again, we're still here. If you still want to chat with Vince, you're more than welcome to. But I just, like I said, wanted to be respectful of anybody's time that has to pop off.
And if you think of something after this, please feel free. I think you should have gotten my contact info in some of the material that came out ahead of time. Feel free to call me too. I'm and I offer this to the DMAR group as well, is that if you have questions, call me. I talk to you on the phone for 10 minutes. I'm not gonna send you a bill. Okay.
I have a quick question. You
Yes.
touched a little bit on businesses or joint tenants with, let's say, another person. I own a building with.
I'm sorry, you're on mute now.
You muted.
Okay.
You own a building, that's where I last heard.
With another real estate agent.
Okay.
And I'm trying, so would I put that into a trust also? Or how do you do that if do you have to have a separate trust with them, or?
You don't have to, no. So are you tenants in common? Is that how you own the?
Comments, right?
Yeah, you can transfer your tenancy in common to the name of the trust, and the trust can hold that. Now, sometimes deals like that are more of a business come along with other restrictive covenants among the owners that say, if you die or I die, I get right of first refusal. So make sure you don't have any of that stuff going on. And if you don't, if it's just the title is the deal, then yeah, you can transfer your tenancy in common into the name of a trust that you create.
So is that something you would be able to review? Because this has been over 10 years that I don't even remember how we did it when we bought it. I mean, I have all the paperwork, but
yeah, dust it off. Yeah, I'd be happy to take a look at that for you, no problem.
Okay. Thank you.
Yeah.
Vince, I have a question. Oops. Did you go
Yes.
away? Oh, there you are.
I'm
My screen just went all crazy. With the seller's property disclosure, I actually have a deal going right now. It's under contract and there is a personal representative. In the listing contract in paragraph 18, they have the choice if they want to provide a seller's property disclosure or not. She chose not to. She knows absolutely nothing about property. She's a friend of the family. Yeah. That's fine, right?
Yep, absolutely.
Okay.
Yeah, and as long as yeah. So you might, so if your listing contract says that, you've got to continue to take a look at the real estate contract, right? Because the real estate contract is going to govern the transaction.
Right.
And you look at paragraph 10 and it talks about property disclosure, inspection, indemnity, all that stuff. If you're going to have a seller that's not going to give one and a buyer that's okay with not getting a property disclosure, I think you need to add another an additional provision to the contract that says, notwithstanding paragraph 10.1 and 10.2, the parties agree that no seller's property disclosure will be, and make sure everybody knows what they're doing and not doing. So I hope that answers the question.
Now, on the first page of the contract where all the dates are, where it says seller's property disclosure and then gives you the deadline, we put in there, seller's property disclosure is not being provided. Is that good enough? Not quite.
Yeah.
Take it to court.
It's better than nothing, but
It's the
I've
investor buying, and they're buying it as is. They did their inspection, but they could back out, terminate, get their earnest money back, but they are not asking the seller for anything.
yeah. And just so you know that every real estate contract in paragraph 10.2 says that you're buying as is, where is, and with all faults. So yeah, that's better than nothing. I'm especially after this case, I'm really like, oh my gosh. I would probably advise putting something in your additional provision thing, just saying buyer and seller both acknowledge that seller will not be providing seller's property disclosure, period.
Okay. Even though I
Just
wrote it in there. Okay.
overkill is better in that regard.
Yeah, usually I do overkill a lot.
Yeah.
33 years, you learn to.
Yeah.
Vince, you did a great job. Thank you very much.
Thanks. You all did a good job of listening.
Well, you had things that we needed to hear.
Good.
Well, thank you, Vince. We always appreciate Women's Council having you here and speaking with us and offering the 2CE. So, of course, we will try to have you back whenever we possibly can, but appreciate everybody for showing up. And again, if you have any questions, feel free to reach out to Vince directly. His phone number's 303-465-5555, correct?
Yeah, right.
All right. Have a great rest of your day, and thank you so much for attending, everybody.
Thanks, everybody. Bye.